Hello. We have sound now. We probably have sound now. Looks like we might have sound now. Some bitch. Sound. Sound. You don't really care. McClintock J. Dissenting. In a brief outline of the basis of my dissent, I will agree with the majority that under the common law, limitations of actions are governed by the law of the forum. Section 1-3-117 Wyoming Statute of 1977 is a so-called borrowing statute. Changes that rule only to the extent that we are required to apply the limitations of another state, if it is determined that the cause of action arose in that other state. The majority recognized both that a wrongful act and resulting injury are necessary to effect an actionable tort, and that the law of the place where the plaintiff sustains the injury to her person controls. The record does not disclose, and neither the jury nor this court could find the specific state where either the wrongful act took place or the plaintiff sustained the injury to her person. An essential prerequisite to the application of our borrowing statute, namely that there be a state from which to borrow, is therefore lacking. However, it might be logically consistent with Wyoming Statute 1-3-117 to hold the action barred if, by the laws of all the states where the action might possibly have arisen, the action is barred. That is not the situation here, since Nebraska and Wyoming, both of which are states where the injury could have taken place, have 4-year statutes, and both are discovery states. My essential disagreement with both the majority and the concurring opinions is with their concept that discovery of the wrongful act and resulting injury is an essential condition to the existence of an actionable tort. I would hold that discovery is of importance only in determining when a statute of limitations begins to run. I would then hold that the defendant who bears the burden of proving facts bringing this case within an applicable statute of limitations has failed in that burden. I would therefore not dismiss the action. Justice McClintock stated his opinion that the wrong was committed only when the disease was communicated to the plaintiff and discussed incubation periods. Consistently with the proper holding of the majority that is the law of the state of the injury and not of the wrongful act that determines whether a tort has been committed, it is possible that a tort could have become complete in any one of 11 states in which the plaintiff and the company of the defendant or separately found herself during the 18-day sojourn between their first contact and confirmation of the existence of the disease in plaintiff in Washington on April 22nd. Although as a law in the place of injury that governs, the majority briefly and I think arbitrarily dismisses Wyoming as a possible place of wrong because no sexual act took place therein. If transmission of the disease through sexual intercourse is not certain, and if there is an incubation period, then it is possible the transmission and planting of the infection occurred in one state and took effect in the other. The defendant does not plead the statute of limitations of any particular state and claims only that the action was barred in the provisions of our borrowing statute under Wyoming Section 1-3-117. In this court, he relies on the District of Columbia's 3-year statute. I would hold that statute is applicable on the basis already discussed, and since he has already shown no other statute which governs and has not shown that the statutes of all possible places of wrong have run, he has failed in his burden. From thus, it follows the action should not be dismissed. Yep.